Today we're going to talk about buyer representation agreements. This webinar is going to cover a better understanding of CAR forms BRE, BRNE, and BRNN, which are all the buyer representation agreements. And we'll also touch on some things that are evolving in the industry that could bring buyer representation agreements into the mainstream a little bit more, depending on the direction of the industry. So here's the introduction. The selling agent, the buyer's agent, in a real estate transaction in California has almost always done so without the benefit of a written agreement with the buyer. Buyer's agents, who typically receive compensation for their services from the listing broker pursuant to the MLS service agreement, often do not see any need to have a written agreement with the buyer. Compensation arrangements, though, are not the only reason to enter into a written agency agreement with a buyer. As the real estate brokerage models change, there may be more reason now than ever before a real estate licensee working with a buyer to document that relationship, including possibility of payment. Although only a small number of buyer's agents enter into contract with buyers, that may change in the near future. And I'll show you an example of that towards the end. But why did CAR create these buyer representation forms? CAR first created an exclusive authorization form for buyers and brokers in 1989 to help those brokers who believed in the practice to document their relationship with buyers. Over the years, this form was regularly revised. In 1998, in the case of Field versus Century 21, the California Court of Appeal held that the 2-year statute of limitations in the 2079 series does not apply to claims of breach of fiduciary duty brought by a buyer against that buyer's agent. This opinion also raised questions about whether any of the other statutory limits found in the civil code applied to buyer's agents. Subsequently, California jury instructions adopted language which could be interpreted as expanding the fiduciary duty that an exclusive buyer's broker owes a buyer. As a result, buyer's agents can no longer look to the statute for protection, definition, or clarity with regard to the nature of relationship that the broker had with the buyer. In light of these developments, the CAR Standard Forms Committee explored whether a contract could be created which would bring more certainty and predictability back to the buyer-broker relationship. Ultimately, the committee decided not to only revise the existing exclusive compensation form, but also to create 2 new forms: the non-compensation and non-exclusive buyer representation agreement, and for compensation, non-exclusive buyer-broker compensation contract. By creating these 3 forms, brokers would be able to decide which type of form would most acceptable to their own customers. The main purpose of risk management, compensation, and full disclosure of and consent to all aspects of the agency relationship are compelling reasons to use these forms. So what is the standard CAR form for buyer representation agreements? CAR has created 3 forms that document the buyer real estate licensee relationship. 3 forms are the Buyer Representation Agreement, which is Form BRE, the Buyer Representation Agreement Non-Exclusive Form BRNE, and the Non-Exclusive Not for Compensation Form BRNN. What are some of the essential features common to all 3 forms? So all 3 agreements define the scope of the tasks and duties to be performed by buyer and broker, provide a written consent to dual agency. Do all agreements obligate a buyer to compensate the broker? Form BRNN does not obligate the buyer to compensate the broker, even if the broker identifies specific property for the buyer and negotiates on buyer's behalf of that property. Both forms BRNE and BRE obligate the buyer to compensate the broker. However, both of these agreements provide as a default provision that if the buyer's agent receives compensation from another source, then this amount is credited against the buyer's obligation to pay the broker. Are the buyer representation agreements legally enforceable? Yes, courts have upheld buyer representation agreements as legally enforceable. Why would a buyer or buyer's agent want to sign a buyer representation agreement that does not have a compensation component? Form BRNN, like others, establishes in writing the terms of the contractual relationship between the buyer and the broker. It prevents misunderstanding about who is responsible for various elements in the real estate transaction. Form BRNN is a convenient way for a broker to make sure that his or her expectations match the buyer's. Additionally, if buyers know upfront what to expect from their agent and themselves, they can take appropriate steps to protect themselves rather than relying on a broker who may not have the expertise in certain areas. Brokers also benefit because the terms of the relationship and duties are spelled out instead of being established by verbal representations, conversations, and actions. Clarification of responsibilities and limitations work to everyone's advantage. Is a buyer able to enter into more than one agreement with different brokers? Yes, but depending on the agreement, there could be consequences. Form BRNN is both non-exclusive and revocable. A buyer would not be in breach of one of these agreements if the buyer also entered into another agreement with a different broker. If a buyer entered into multiple buyer representation agreements, it is likely that the broker would question the sincerity of that buyer and the broker could revoke the agreement. A better practice for buyers would be to revoke a BRNN form if the buyer decides to work with an agent in a different office. Both of the forms BRE and BRNE, the compensation contracts, are irrevocable. With the exclusive form BRE, even if a buyer signs an agreement with another broker, compensation would still be owed to the first broker with a written agreement if, during the term of that agreement, the buyer purchased property defined by that agreement. With the non-exclusive BRNE form, a buyer only owes compensation to the broker with the written agreement if, during its term, the buyer acquires property that was introduced to the buyer by that broker or if the broker otherwise acted on the buyer's behalf. Specifically, what information is contained in these three forms? So number one, a paragraph that identifies the parties to the agreement and provides a recognition that the licensee's duties will be performed either by an individual broker or an associate licensee in the broker's office. Number two, a paragraph identifying the authority of the broker, including activities such as locating and presenting properties and offers, assisting with loan pre-qualification, providing lists of professional vendors or service providers, and scheduling and attending meetings. Number three, a paragraph that identifies the duties of the broker, including providing and reviewing forms, conducting an on-site visual inspection of the accessible areas of the residential 1 to 4 property, facilitating the escrow process, and delivering materials in the licensee's possession. Number four, a paragraph that establishes the limits on the scope of the broker's services. As an example, the buyer agrees that the broker is not responsible for inspections that should more appropriately be made by other professionals, that the broker does not guarantee the performance of others or the condition of the property, and that the broker will not verify square footage or boundary representations. A paragraph that identifies the responsibilities of the buyer in the transaction. These include hiring professional inspectors and notifying the broker in writing of specific concerns. Number six, these agreements allow the broker to engage the buyer in a single agency only, buyer's exclusive agent, or as dual agency should the agent elect to represent either sellers or other buyers. Number seven, these agreements allow the broker to engage the buyer in a single agency only, buyer's exclusive agent, or as dual agency should the agent elect to represent either sellers or other buyers. Number 8, a paragraph that establishes that the entire agreement between the buyer and the broker is contained in this written agreement, which cannot be modified except by a written agreement between the parties. And number 9, a place for the buyer and broker through an associate license to sign the agreement. Are there any clauses in the form BRNN which are unique to that agreement? Yes, the agreement does not end on a date certain, but instead expires upon written notice by either party or completion of a transaction as contemplated by the agreement, whichever occurs first. What are the clauses in forms BRE and BRNE which are different from or in addition to those in the BRNN? Definite commencement and termination dates that must be written into the first paragraph. Both agreements have a paragraph in which the property buyer is seeking to acquire is defined in terms of the type of acquisition, location of the property, price range, and other features. The broker is authorized to obtain a credit report for the buyer at the buyer's expense. Both agreements obligate the buyer to provide relevant personal and financial information to demonstrate the buyer's ability to acquire the described property. If the buyer does not provide the information or is not qualified to acquire the property, the broker may cancel the agreement. Both agreements have compensation paragraphs that obligates the buyer to pay for the broker's services. Both of these agreements give the buyer a credit against this obligation as a default provision. However, if the broker receives compensation from another source, such as the listing agent or seller. Both agreements have a mediation paragraph and an optional arbitration paragraph. Both agreements have attorney's fees paragraph that provides that the loser will pay for the winner's attorney's fees in connection with a claim regarding the broker's right to collect compensation. So what are the differences between forms BRE and BRNE? The exclusive agreement, BRE, provides for the broker to be paid if the buyer acquires the described property during the term of the agreement, no matter how the buyer learns of the property. The non-exclusive agreement, BRNE, provides that the broker will be paid only if it is the broker who introduces the property to the buyer or otherwise acts on the buyer's behalf. When should the broker and buyer sign any of these agreements? It's best to have these agreements signed at the earliest possible time in the relationship with the buyer. If not done at that time, it is advisable that the form should be used no later than when an offer is written. Anytime that an agency disclosure form, Form AD, is given to a buyer, it would be a good practice to also provide the buyer with one of these 3 agreements. These agreements will also substitute for the DA, disclosure and consent for representation for more than one buyer, so the DA need not be used where the buyer representation agreement has been provided. Will buyer representation agreements become more prevalent as the industry evolves? So a major MLS rule change announcement was recently posted in the Seattle market. This was brought about as a proactive solution to class action lawsuits brought about in 2019 regarding lack of transparency in agent compensation with consumers. So you may have heard about some of the ongoing lawsuits, class action lawsuits, about the lack of transparency that's going on, and how some of the MLSs are starting to change their policy. So for reference, SOC stands for Selling Office Commission. So this was a newsletter that was put out by the Northwest Multiple Listing Service up in Washington. This is not the entire letter, but a portion of it. So they made a rule change to increase the transparency and flexibility for consumers and brokers. So this was in July of last year. The Northwest Multiple Listing Service today announced it is making changes to its rules in a move to increase transparency and flexibility for consumers and it's more than 30,000 real estate brokers. The rules revisions allow real estate firms to publish the amount of commission the seller is offering to pay broker representing the buyer, known as the selling office commission, or SOC, on the firm's public websites, along with other listing information such as list price, square footage, so on and so forth. Making this information readily available to consumers will allow for complete transparency with regard to buyers' brokers' compensation and provide consumers with an additional form at the outset of the transaction. So what they did is they are publishing publicly the buyer's compensation. So, you know, the 2% or 2.5% or, you know, whatever the percent being offered is now public on the websites and the third-party sites such as IDX sites and so forth. The change also removed the requirement that a seller offer a SOC when listing a property for sale, and if there's no SOC offered, allow the buyer and the buyer's broker the opportunity to negotiate the compensation of the buyer's broker as part of the offer to purchase. This revision allows greater flexibility for sellers when listing a property, while affording buyer and buyer broker a vehicle for negotiating the compensation for the buyer broker services if no SOC is offered. So they're not requiring there to be a co-op now. So you could show up to a listing appointment and the seller could say, I'm not going to offer any compensation to a buyer's agent, and it would be published in the MLS that way, and it'd be up to the buyer's agent to negotiate that with the listing agent and the seller. So this would probably be a good time to have a buyer broker agreement in place should one of the properties that the buyer liked not offer the selling agent compensation. So this is, you know, this is in one market up in Washington. Is it going to grab hold and come into other markets? Well, it's tough to say. It hasn't yet. It's been, you know, 9 months since this came out. But, you know, these are on the West Coast, so we can definitely think that here in California, something like this could be in the works, could be coming down the pipeline with some of the different MLSs that we have here. So aside from allowing brokerage firms to publish the buyer's agent co-op publicly, they also added, and I just read that, that they're allowing the seller to not offer the compensation to the buyer's agent. So how would a rule change like this affect our business here in California? Some things to think about and possibly prepare for. Buyer broker agreements may become more prevalent and also easier to justify if you've had problems with buyers sending them in the past. Buyer's agents' earnings may drop. Negotiating your commission on the buying side may become the new norm. Seller refusal to pay extra commission to a buyer's agent for bringing a buyer may become more of a discussion sticking point at listing appointments. Increased buyer closing costs on home purchases where the seller is not offering compensation to the buyer's agent. Meaning, you know, if there's a buyer broker agreement in place and they have a certain amount of commission stated in the buyer broker agreement and the seller's not paying for it, that's going to get passed on to the buyer, as well as all their regular closing costs from the lender, title escrow, so on and so forth. Buyers may start asking for rebates from your commission more often, especially when an agent bonus is displayed publicly. So if the MLSs do start publicly displaying the offered compensation and it's higher than maybe what the buyer thought it would be, or if they start calculating in their head and they don't think it's justified, they may start asking for more rebates. So you'll need to have some objectives for that. Procuring cause disputes may rise as buyers may try to jump from agent to agent to get into the home they want. So be sure to brush up on the rules. I'll probably do a a webinar here shortly on procuring cause. Declining, accelerating market conditions may dictate agent commissions more strongly. One thing is for certain, if this real change comes to our market, the old saying, you need listings to last, will stand true more than ever. I say this over and over and over again. There's nothing wrong with being a buyer's agent, but if you want true control of your business, you need listings. Why? The listing agent will all but guarantee a commission earned on a sale from their listing fee. Buyers may look to work with the listing agent more often to save themselves from paying a buyer broker on transactions where the seller is not offering a co-op. You know, in hot markets, I mean, we see it right now. Buyers try and work with the listing agent more often because they think that they have a better chance of getting the home, or can negotiate with the listing agent's commission to get a lower price on the home. This could become more prevalent if this were to come to our market. So if you have any questions on this, you want to discuss, obviously I'm not trying to scare anybody with things, as this is not something that is in our market currently as of February 2020. But it's good to know what changes could be coming down the pipeline and what other markets are doing, especially markets that are similar to ours here in California. You know, Washington's a West Coast state, so a lot of the rules are similar throughout the West Coast here with regards to contracts and normal industry things going on. So keep that in mind. If you ever want a game plan or anything, just give me a call.